Okay, can you hear me? Can you all hear me? Okay,
Yes.
wonderful. Thank you so much. I am grateful for this opportunity to be here. Thank you, Chair Camila Moore, and the members of the task force. Um, my name is Deidre Farmer Pellman. I am Executive Director of the Restitution Study Group. I'm thrilled to be here also, finally speaking with Mary Frances Berry, because quietly she has played a major role in our work. So that's all I'm going to say. Okay. But as far as the restitution study group is concerned, we actually work with quite a number of different organizations. We are an institute that engages in research as well as litigation against companies that are complicit in slavery. At least we have found documentation verifying their complicity in slavery. Some of the other organizations that we work with and kinds of things that we do with them, one organization is the New Future Foundation, headed up by Dr. Delois Blakely, Queen Mother Dr. Delois Blakely. We are engaged in DNA testing for self repair. We actually go to Africa, we test Africans, we do DNA tests, and we have created a database where we connect descendants of enslaved Africans with their actual African families. Now, we didn't know this was going to be possible. We gave it a shot in 2015, and it was effective, fourth and fifth generation separation. But believe it or not, a lot of us are still in very similar occupations. And when I say occupations, specialties. Um, and specialties, that is, if you're gifted in history, singing, orating, your cousin may actually be engaged in very similar work somewhere in Africa. So this is one of the things we do, DNA testing. A part of that DNA effort is Antoinette Harrell Miller, who heads up a genealogy organization here in the United States. And we call her the peonage detective. There's documentation online about the peonage research she does, uh, researching families. We're able to do a lot of research connecting families. So that really is, I never thought of that as an issue. We've been doing this research since 2004 when DNA testing became publicly available. In addition to that, we also, in addition to her, we also work with Sister Empress Chi, who is the founder of the Million Women March, the one that took place in 1997 out of Philadelphia. We work very closely on the issue of genocide, and in particular, most recently, we issued an open letter to the President of the United States, who is the person who carried the genocide uh, bill through Congress, which is the law of the land. It's called the Proxmire Act, and we are asking for him to use that law because it addresses many of the issues that, for example, HR 40 would address. Because quiet as it's kept, descendants of enslaved Africans are victims of genocide. And I'm going to talk a little bit about that. And that is the injury that we all continue to suffer from, in part because we've been separated from our national and ethnic groups, and we are subjected to conditions in life that are really destroying our survival in whole or in part. And these are issues, these are areas that are covered by the genocide law, the Proxmire Act. Okay, so how did I get involved with all of this? I'm going to say that I was sort of spiritually drawn to the work around reparation. Um, I was actually an activist in the gay and lesbian community where I worked with musicians, women drummers in particular. And I was invited to help with an event at the African Burial Ground in New York City because I knew a lot of women drummers. What was happening was that a burial ground had been unearthed, a burial ground from I guess it was from the 1700s, and it was filled with the bones of what they realized were enslaved Africans. They knew this because some of the burials, uh, some of the remains had teeth. Thank you, number one. Thank you, dry bones, right? Some of the Some of the enslaved people had teeth carving. In other words, there were carvings on their teeth that were clearly traced to African tribes. Okay, so so this burial ground was just outside the Wall Street, and the enslaved people were actually considered the original stock at the stock market, which was an area that was just blocks away. They were bought and sold right on the waterfront in Lower Manhattan. I was invited because I was involved with media. I worked in the press office at the Department of Health, just one block away, and it was very convenient for me to walk over. But this image that you see on the screen now is a photograph taken by Chester Higgins Jr. down in the burial site. I actually saw this live. I was shocked. If you look at the face of this enslaved person, this skeleton, you see the mouth is open. Now, not all of them look this way, but this one in particular had the mouth open, and I thought I asked, did they die screaming? And I was told no. They this the bones opened up when the jaw muscle deteriorated. But I was absolutely horrified. I was haunted. I had to do something, and I made a decision that I was going to try to find out, more about what I could do to deal with this issue of reparations. Now, why reparations? When I was a kid, my grandfather used to always talk about the 40 acres and a mule that we were owed, and it stayed with me. And I knew that there was something here, and so I applied to law school. And I specifically declared that I wanted to be an architect to build a case for reparations. And needless to say, I didn't get accepted to too many law schools, but I certainly got accepted to the one that I needed to go to, and that was New England School of Law in Boston, Massachusetts, that happened to be right next door to Rhode Island, which turned out to be one of the most critical states engaged in the slave trade. And I'm going to talk a little bit more about that. Now, so I went to law school, and I wanted to know, okay, what is the kind of case I would pursue for reparations? And I thought it was going to be the government, but after learning about, and I was there at a good time because there was a case out of California, Cato v. US, where there was a decision that the folks could not sue. There were people that filed pro se, that was on their own behalf without an attorney. The decision was that they could not move forward with their case because the federal government had not waived its sovereign immunity. So I had to think about what other possible ways one might go about pursuing reparations. And I began to look at private estates and corporations. And the reason why they seem more accessible is because I learned about other arguments that could be made other than, for example, a case against the government. I looked at something in the area of equity, the law of equity, or the law of restitution. And basically, what I learned is that, if you can make an argument that a party has been unjustly enriched, you might be able to persuade a court to decide in your favor. And so that was the theory that I was moving forward with, unjust enrichment. I did this paper and ultimately applied to an internship. Actually, I worked with NCOBRA. That was when law students are typically trying to get into law firms. I was looking for the place I could build this case. And NCOBRA, my mentor was on the panel earlier today, the person that supervised me for a whole summer, Adjoa Ayatoro. Spent the whole summer working with her. I studied the 13th Amendment, I think maybe even some 14th Amendment, but mostly 13th Amendment. But we didn't touch on this particular theory, but at least they knew my heart was there. I had to wait until I graduated from law school to begin developing a case. And one of the companies that I learned about, and thank you so much for switching the slide, was Aetna, Aetna Life Insurance. As a student, I learned that they had written slave policy. So when I graduated, I called them up and I asked them, for copies of slave policies. And in particular, I asked about policies that might have been written on my own ancestors. And they said, well, we don't have any from the state we were from, South Carolina, but we'll send you what we have, and we'll send you some things on some other companies as well. And so what you have here in figure 2 is a copy of a slave policy written by Aetna in the I guess this was the 50s, the 1850s, excuse me. But this was written on the life of a group of enslaved Africans. Okay, the beneficiary of this policy was the slave owner. Okay, so if you look, you can see the young ages. The 10-year-old, there's a 10-year-old, there's an 18-year-old, a 15-year-old, 19-year-old. It even lists their occupations: nurse, cook, and so on and so forth. Bottom line is that these policies were written at a time when the transatlantic slave trade had closed. A lot of enslaved people were expensive, and a lot of folks might not have purchased an enslaved African, but for the fact that companies like Aetna, they go ahead, make the purchase. If they die, we have you covered. Now, they didn't cover for the full value of the enslaved person's life. And if you can see in those columns here, you can see the value of the person might be 400, but they're covered for 300. And that was to discourage the slave owner from working the enslaved person to death. But nevertheless, it did happen. And in fact, it happened in the case of, for example, New York Life Insurance Company. They were called the Nautilus Company. When they were founded, their first 100 policies, 1/3 of them were written on the lives of enslaved Africans. And the first policy that was ever paid out was on the life of an enslaved African, someone who worked in coal mines. And this is one of the things that these policies help make happen. The employment of these expensive humans, these expensive chattel, in ultra hazardous capacities. So one of the things you have to think about, when you see that New York Life Insurance Company commercial, is that it's the company that made it possible for us to be enslaved in ultra hazardous capacities, and they made money off that. 1/3 of their first investment, this is where the money came from slave policies. When I pulled Aetna up, I didn't call up alone. I did reach out to reporters to let them know what was going on. And that was in part my own insurance, so to speak. I didn't want them to think, I was trying to do anything for myself. I made it very clear to them that I wanted them to create a trust fund that would benefit the descendants of enslaved Africans. I wasn't interested in anything for myself. This was for everyone. And they said they would do something, but when the story hit the media, they changed their mind. And at that point, it became clear that I might have to do more than just call them up and give them a chance to be proactive and do something great. One thing that worked out in my favor at that time was that Tom Hayden, a senator from California, learned about Aetna and decided that he was going to introduce a bill that initially was called the Aetna Bill. Okay, and I think he made that decision very quick. Probably like the story broke in late February, Black History Month in 2000, and by March he had already introduced the bill. And by the end of September of 2000, the bill had passed. It became the first slavery ever disclosure law in the United States. And it required that any insurance company doing business in California would have to report on their role in slavery. Now, this bill was not just designed for the state of California to be informed, but it was designed so that descendants of enslaved Africans could have access to documents that would help us to reconnect with our families. I mean, once again, I mentioned earlier uh, the DNA testing that we are engaged in, and that's all part of reversing this thing called genocide. Okay, so these bills were designed to assist in that process so that we can find ourselves, so we can pull our families back together. So that's, I want to mention that because I'm going to talk a little bit more about those bills in a second. Okay, so I'm listing a few of the companies that ultimately we realized we just had to sue. Fleet Boston Financial Corporation, today is called Bank of America. They were in the litigation, and so were these other companies. But basically, the banks played a role in financing slave trading voyages, or they gave loans to slave owners and used enslaved people as collateral. These are some of the circumstances. The insurance companies, like I said, Aetna, New York Life, these are companies that played a role in financing the enslavement. Lloyd's of London, very unique. The Zong case, you're going to see a little something about that. Comes out of Lloyd's of London. Companies that were engaged in the same kind of business Lloyd's of London is involved in. They finance this transatlantic slave trade. Okay, and the way they worked was that if an enslaved person was sick during the voyage, the policy, the practice was to dump them in the ocean while they're still alive, because if they get to the shore and they die, these companies will not pay the insurance to the folks that own the slave trade voyage. Okay, so Lloyd's of London, that's pretty much what they stand for. There were other companies involved in that. AIG is another insurance company, similar stuff. These are companies we sued, by the way. CXX Corporation, these railroad companies, they used enslaved Africans to lay the tracks. Those same tracks that we ride on today around the country, enslaved Africans laid those tracks. They brought in folks from other countries at some point, but enslaved Africans laid those tracks throughout the South and other parts of the country. The tobacco companies, you know the story. That's a little bit more typical, what we know of, planting and packing tobacco. So these are the kinds of things that the kinds of companies we sued. Now, so let me see. We can move to the next slide. So the kinds of plaintiffs. A lot of people talk about slavery as if it's ancient history. What they don't realize, at least I didn't even realize this. Actually, I have to thank someone who I haven't spoken to in a long time, and I pray that she's still with us. Ina Daniels Hurdle McGee is her name. This is somebody who I just happened to see after an event, who just had a package of information that she wanted to share with me. She loved to meet centenarians and learn their stories, and she wanted to share with me information about people she had met, people who had been enslaved or who were the biological sons and daughters of slaves. And so, you know, I paid attention to her, and I tend to pay attention to everybody that brings me anything. So you know, you guys pay attention to what my email address is and reach out to me if you have any kind of story. But the first person here, Timothy Hurdle, is actually her uncle, and Timothy and his sister and the brother were plaintiffs in the case, but they are the biological sons and daughters of someone who was enslaved. And so Timothy is holding the picture of his father. Emma Marie Clark was enslaved. She was a plaintiff in the case. She, gosh, I can't remember her age when she passed away, but she was actually enslaved in the South, and she was discovered on a dairy farm that actually did accommodations, kind of like an Airbnb kind of thing. She was not able to accept the tip she told them because she's a slave. And the folks reported it to the FBI, and the FBI actually emancipated Emma Marie Clark. But she was a plaintiff in the case. And we had others. There were other families that were enslaved. One really a large family, maybe 8 plaintiffs. and there was they were enslaved until the 1960s. They never knew that Black people were ever free. Okay, um, other biological sons and daughters, and of course, then there were people like me. My story is basically my grandfather, who I went to when I was going to develop this case in law school, told me that his grandparents were enslaved on St. Helena's Island in South Carolina. We're Gullah people, um, and that they ran away at the beginning of the Civil War. They stole a boat and then they stole their freedom. They left. It took them 2 weeks to travel from St. Helena's Island, where I'm not sure if it was cotton or rice. I think it might have been rice that they dealt with, but I'm not sure. Um, 2 weeks to get to Georgetown, where they were able to blend in with folks there. But that's the story that my grandfather told me, Clara and Abel Hines, and that's the story I worked with. And and I mentioned earlier that when I reached out to Edna, I asked him about that. Interestingly, by the time we filed the lawsuit, the California Slavery Ever Disclosure report had become public, and it was May of 2002 that it became public. And there was just one record I learned that had not been included in the original report. That one document had to be transcribed sometime in July of 2002, we got the information. Turns out that the person was named Abe, from the same region that my grandfather was from, and I'm sorry, Abel. And so, as far as I'm concerned, that was my great grandfather, the person that my grandfather told me about. First of all, they told me they didn't even have policies in South Carolina, but here you have someone with my ancestor's name in the area of South Carolina. So I found that fascinating, but very important, because this is the point of these slavery era disclosure laws. Now I'm going to talk a little bit more about those laws, because they exist for a reason. Well, you know what? Before I talk about that, let me just mention one other thing about the litigation, our causes of action, and what happened in the case. We basically had two types of argument. We had some historic arguments that essentially were about slavery was a crime against humanity. Those arguments basically were based on the initial enslavement of our ancestors, although we did talk about the harms that we continue to suffer from, that we call vestiges of slavery, and that some of the actions and the withholding of documentation about the role that the companies played in slavery constitute a continuation or fraudulent concealment. And the court did not necessarily go with those arguments for everyone, but they did recognize that there were some plaintiffs who had standing, who themselves suffered the injury and were close enough to, for example, being the biological sons and daughters of slaves, that they could carry their case forward. And so those cases were allowed to move forward. The next category, the next argument we have were consumer fraud arguments. And those were based on the fact that many of these companies, when confronted with information about their role in slavery, lied. They lied to the public. And, it's interesting because there was a law review article written by Tara Kola Ramchandani from Harvard University, where she talks about the judicial recognition of harms of slavery, consumer fraud as an alternative to reparations litigation. And basically, what she argues is that if we were able to complete our litigation, we would have been successful on the basis of the consumer fraud arguments. And that is because the court actually held that we can move forward with our consumer fraud arguments. Okay. I'm getting an echo. Okay. Okay. Are we okay? Should I continue on?
Yes, please.
Okay. The consumer fraud arguments were good, and so that was the good law, and that is why we say that we had an unprecedented legal victory. You know, never in the history of our freedom have we had any kind of victory on the issue of reparations. And here, in the context of consumer fraud, the court said we could move forward. Unfortunately, we ran out of money and we could not pursue those claims, but nevertheless, the precedence is there. And so at this time, we find ourselves with companies who, believe it or not, continue to lie about their role in slavery. And they're doing that in the context of the slavery era disclosure law. Now, I mentioned those earlier. I talked about California having been the first. In California, you guys, you are the first in so much. Thank God for you. About 14 other slavery era disclosure laws have been passed around the country, all of them sort of following in the steps of Tom Hayden. They are in municipal governments or they are state governments, just a variety of them. But you happen to have a few really great ones in California, and one that I've been paying attention to is in San Francisco. And I've been tracking their reports, and I have discovered that one company really is very stubborn about telling the truth about their role in slavery. And at this point, I'm going to give you what I think the Restitution Study Group can help you with. You need to know who should pay. I don't think it should simply be up to the taxpayers of California. I do believe that these companies that are lying on these slavery era disclosure reports should be held accountable. And some of the laws, like the one in San Francisco, does create the opportunity. First of all, these companies can be punished based on their profit for their lies about their role in slavery. But I want to tell you one of the companies, and I'm going to sort of hint at one because we're still doing research around the other one, but Bank of America, unfortunately, they do not want to share the history that they have in slavery. And what's unique about it is that they played a role in slavery. Their predecessor company, the bank was called the Providence Bank of Rhode Island. Bank of America issued their slavery era disclosure report. And let me see, I think it was in the 17th, I think, 2017, June of 2017. Let me see, this may be a little earlier than that, but let me just say this, that the report is part of a report that was issued by the clerk for 2017. Bottom line is that they claim to have done research on the Providence Bank of Rhode Island and have found no documentation connecting them to slavery or the slave trade. But it is widely known that their bank, Providence Bank of Rhode Island, is a bank that served slave traders. And in fact, slave traders founded the bank. It was founded by John Brown, who was an advocate for the slave trade. He was like the major spokesperson for slavery in the state of Rhode Island. He founded the bank. He was engaged in slave trading at the time, and so were many of the other shareholders. And the bottom line is that it's very difficult to find the documentation, but we were blessed to have gathered up primary documents for at least 28 voyages. And just for these 28 voyages, the violation of state and federal law should have yielded the current value, $35 billion, okay? This is how much money they should have had to pay. Of course, this is the present value based on the number of slave trading voyages and the number of enslaved Africans. And so, just to give you an idea, that's just one example. Another example is a company, as I said, we're still working on the information, but they'll know who they are when they hear what I'm saying. This particular company is associated with Barclays. Now, we did research on Barclays, and we initially, Barclays Bank did not want to share the truth about their role in slavery. And the Restitution Study Group engaged in a report research to issue a report where we found that the bank actually was responsible for 125 slave trade voyages. And in the course of those voyages, something like 38,620 Africans were enslaved. Okay. And of that number, 6,045 never made it from Africa to the Americas. Okay. They were lost at sea. Now, one of the things I mentioned a little earlier was about the Zong. Thank you so much. About the Zong case, the slave ship murders. And what was happening here, once again, was that they were dumping them at sea. They didn't think they were going to make it to shore alive. And this is how they ended up. But we call this is straight up genocide right here. And I don't know the exact total number of Africans that ended up in the ocean, but there's a substantial, millions of us ended up dead at sea. And we were dumped alive. And that's really important to know when you think about these companies that played a role in slavery. So once again, with this Barclays research, there's a major company, probably one of the largest of its type in the world, that's associated with Barclays. And on their report, they did not mention anything about this 38,620 enslaved Africans associated with their business. So what I say to you all is that please do consider these companies. There are many more. As far as the Restitution Study Group is concerned, we are engaged in preparation for litigation against some of these companies because, of course, there are consumer fraud laws that are being violated. We all are relying on these reports to be able to trace our ancestors. We want to know, where did these folks end up? And that brings me to one other issue that comes up a lot. It's very controversial, but I'm going to put it out there. Who should be compensated? Okay. Now, based on the research that we do, the Restitution Study Group, we know that with these companies, especially the ones that engage in the transatlantic slave trade, the people that they enslaved did not all end up in the United States, right? I'll give you an example with the Barclays research. Of that 38,600, just give you some percentages. We use the Transatlantic Slave Trade Database to gather this information, but we know that 48% of them ended up in Jamaica. Okay, about 8% of them ended up in the United States. Okay, so this is one example. As far as Bank of America is concerned, the numbers, the places that they were dropped off are different. But one of the things I do want to mention about Bank of America, I want to put it in the record, they violated U.S. law and Rhode Island state law. And so they had to engage in dropping enslaved Africans off in foreign countries because Rhode Island did not allow them to engage in the slave trade at all. But the United States government only allowed them to engage in the enslavement of people if they were brought from Africa to the United States. Okay, they couldn't do that. So they had to drop them off in other countries. So most of Bank of America, any wealth associated with their slave trading activity would probably show that Africans were mostly dropped off in the Caribbean. But there are there's indications that many were brought into the South. Okay, so I just want to put that out there. With companies, you're going to have situations where money that they owe doesn't necessarily belong exclusively to descendants of enslaved Africans in America. And what I would recommend under those circumstances is definitely still pursue these companies, because this is just one example. These are just one examples where you have them dropped in different places. Definitely pursue, but create separate funds. that might work for two different groups of people. The alternative
Thank you.
is only focus on what the descendants of enslaved Africans are. Okay, thank you very much.